What's 4,400?
The regulation.
Oh, I thought you were talking about the TV show that was on a while back. 'Cause I was on the phone and I was like, okay. Yes, I do. Oh, when it's yeah, you've been late. I always am late.
Well, you still were. You still were.
And here we go. The July 13th meeting of the Rent Control Board is called to order. Would the secretary please take the roll?
Commissioner Flora. Here. Commissioner Trostis.
Here.
Commissioner Foster.
Here.
And Commissioner Phyllis and Commissioner Duran are absent.
The board will now adjourn and reconvene in closed session. Okay, everybody, it is 7:02, time to get started. Welcome to the July 13th, 2017 meeting of the Rent Control Board. Would the secretary please take the roll?
Actually, we already did the roll.
We already did the roll. Coming back after closed session, please join me in the salute to our flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right.
All right, if anyone wishes to address the board either on a specific item on tonight's agenda or at public comment, please see the secretary, Lonnie, at this time to fill in a speaker slip. And also, as a note, the parking validation machine has been broken somehow, so if you need parking validation, please also see Lonnie right here at the clerk's desk. Can we have a report of closed session, please?
Yes, good evening, Commissioners. The board convened into closed session at 6:12 and adjourned from closed session at 6:40 with no reportable action taken. The board was considering one action of pending litigation. Thank you.
All right, thank you. And if you, if my fellow commissioners can take a moment to look at the minutes from last month.
I move to approve the minutes.
Is there a second to approve minutes?
Second.
All right, voice vote. All those in favor?
Aye.
Aye. All right, the minutes are approved. Thank you. And any announcements or special announcements from staff?
Yes, thank you. I have a couple of things this evening. We mailed our summer mailing and the registration fee bills at the end of June, so everybody should have received those by now. If any property owners have not received the registration fee bill, please contact our office and we will send a duplicate copy out. They need to be paid by August 1st in order to pass through half of that registration fee to the tenants. We will be holding a seminar on Tuesday, July 18th in the evening to assist with the calculation of the annual rent increase and the proper calculation of the pass-throughs. So any property owner or manager who's interested in attending that should contact our office and pre-register so that we can bring information about the property with us to that seminar. And then I wanted to mention that we received written communications this evening from somebody who wants to address the board during the public comment session. So I'm going to pass those out to you. We just received them this evening. So,
Okay.
and that's all I have.
Any other announcements? Okay. It's time for public comment. Item 7, this is the time set aside for members of the public to address the board on matters that are not included on the agenda, but that are within the board's subject matter jurisdiction. Please note that the board cannot take official action at tonight's meeting on any matter not included on the agenda. So if you are ready to speak on your item, please step forward, and I'm aware that we have a PowerPoint presentation first up. Elaine Golden-Geeler, that will take a moment to set up. Whoa.
I'm wondering if City TV is watching. They're usually a little bit asleep at the wheel. So I'm asking that they would please note that there's a PowerPoint and not just show my face, however more beautiful I am. So this is the top 10 ways owners can spend their $40 rent increase. Number 1, paint one wall in a vacant apartment. Number 2, talk to Rosario Perry for 4 minutes. Number 3, talk to Rosario Perry's receptionist for 1 hour. Number 4, listen to Jim Jacobson for 15 minutes. Number 5, pay 1 night of pet accommodations for a tenant comfort animal. Number 6, make a down payment on a parking ticket. Number 7, pay a shoemaker to resole 1 shoe. Number 8, get 6 teeth cleaned. Number 9, buy half a rotisserie chicken at Whole Foods. That one's funny, I think. And number 10, purchase 1 Richard Bloom dartboard. Thank you for watching.
Thank you for your public comment. Next, we have Esther Schiller. You have 3 minutes to speak.
Good evening, Madam Chair, members of the Rent Board, city staff, residents. My name is Esther Schiller. I'm here tonight as a representative of the American Lung Association. I work for them as a consultant. I've brought some new information which was not available when the smoke-free housing law became effective in 2012. If you live in an apartment where someone is smoking, or if secondhand smoke is drifting into your unit, you are at risk from cancer-causing chemicals just from using your toothbrush. And the reason is third-hand smoke. Recently, I was invited to participate in a one-day conference at USC about third-hand smoke. Scientists who are studying third-hand smoke were presenting, and what I learned is that third-hand smoke is more dangerous than second-hand smoke because it changes over time and becomes progressively more toxic. It's the second-hand smoke that sticks to indoor surfaces, to skin, to hair, clothing, and can be transferred into environments where smoking is not allowed, like the elevator. Layers of third-hand smoke residue can build up over time on surfaces and in household dust and can remain there for years. It re-emits from surfaces back into the air, and it gets worse over time. You can be exposed to third-hand smoke if you touch a surface where it has accumulated, because it can be absorbed through your skin. You can inhale it. You can ingest it from household objects like a toothbrush or eating utensils that are contaminated with third-hand smoke residue, which is present in the dust in the air. The scientists at the USC conference were comparing it to asbestos and radon, but stating it's worse because there's no known remedy yet for removing third-hand smoke from an apartment or condominium unit. The residents who worked so hard for passage of the current ordinance felt that eventually everyone would be protected, but eventually can be a long time. Think about the people who will be moving into an apartment that has been smoked in for years and years. As more information is known about third-hand smoke, landlords will need to consider replacing discolored windows and even taking the walls down to the studs because the third-hand smoke is absorbed by drywall. This may sound like a hopeless situation, but beginning to solve it, steps can be taken to reduce this health hazard. In your packet is a document from HUD. HUD was already encouraging totally smoke-free housing in 2012 without grandfathering current residents who smoke, which is what has happened in Santa Monica. Current residents are grandfathered. Also in your packet is the latest letter to the editor written by members of Smoke-Free Living Santa Monica. You have previously voted to place this issue on your agenda. I hope it can be as soon as possible. Thank you.
Thank you for your comment. All right, we are moving on to our jurisdictional items. It's item 10 on your agenda. We have two owner occupancy exemptions, and Todd Flora would like to make a comment.
Unless my colleagues have any objection, these were well-written reports, and I'd be happy to move that we adopt the staff reports, finding of facts, and Karen, I was trying to move items A1 and 2, unless anybody, and move adoption of the staff report to grant the exemptions.
Is there a second? Second. All right, is that a voice vote? All those in favor? Or a roll call? Thank you. Roll call vote, please.
Commissioner Flora,
Yes.
Commissioner Phyllis, Commissioner Trosas, and Commissioner Foster.
Yes.
Motion carries.
All right, thank you. So that means the owner occupancies are exempted for items 10A1 and 10A2, in case there were any questions on how quickly that moved. Item 10B, exemption of a single-family dwelling. The item number is 1815-384. The address is 1101 Marine Street. The applicant is an A. Gomez. Applicant requests exemption of a single-family home pursuant to Section 1815 of the law. Yes, Commissioner Flora.
If I may, Madam Chair, I didn't move this item because I don't recall the last time we heard a single-family home, and I just wanted a little bit of refresher, and this made for a nice
Happy to, Commissioner.
model to do that. Yeah.
Let's have the staff report. Brief staff report.
Good evening, Commissioners. This is exemption 1815-384. The applicant is Mr. Andrew Gomez, and the property is 1101 Marine Street. Mr. Gomez is the sole owner of the property, which he states he has lived in since 1997 when his mother transferred it to him and his brother. Since then, his brother has quitclaimed his interest to Mr. Gomez. Single-family homes qualify for a permanent exemption from the rent control law if an owner can prove that he or she has lived in the home continuously for 2 years as his or her principal place of residence, so long as the previous tenant, if there are any, had voluntarily vacated the property or had been lawfully evicted. Board records show that this property is a single-family home. There is no evidence in the board records to show that this property has been rented at any time since after January 1st, 1999, the date when landlords were required to register new tenancies with the board. Therefore, the requirement that the current owner has occupied the property only after a voluntary vacancy or lawful eviction of a prior tenant is not relevant to this case. Utility, financial, and government records also show that Mr. Gomez has lived in this house for at least 2 years. DMV and city water, sewer, and trash records also show the property as his mailing address. The voter registrar lists his address as the property next door, where he lived in his childhood and where he initially registered to vote. Board and DataQuick records show that Mr. Gomez does not own any other residential property in Los Angeles County, which could be somewhere that he may live otherwise. Looking at the record, the preponderance of the evidence supports the grant of the exemption, so staff recommends that the board do so and adopt the proposed findings of fact and conclusions of law.
Okay, if any commissioners have any questions of staff or discussion. Commissioner Trosas?
Thank you for that. And I have some potentially ignorant questions just because this is the first time that I've heard one of these. What's the property zoned as currently? Do we know?
Unfortunately, I don't have that information in the record because we wouldn't have that in our database.
Okay. Because these are my concerns. What happens if the property is torn down at some point and then rebuilt as multifamily? If they get a conditional or a change in zoning, or the current zoning allows for multifamily?
If a property is permanently exempt, it's permanently exempt.
Right.
And even if it were not exempt, and they Elliston waited 5 years and built a new property, it would still be new construction, so it would be exempt from rent control on that basis.
Right, but let's say they tore down and didn't wait 5 years, and there was no removal.
If it were not exempt, if
Right.
it were covered by rent control,
Right.
then it would then the
Be
units
under-
would be subject to rent control.
Right.
But the board cannot base its decision based on a speculation about what the owner may do with the property in the future. The only question is, does it satisfy the criteria?
Right, and I understand that, on, given the interpretation of the law here, we don't have a choice, but I just wanted to point out that, that hypothetical situation, is of concern to me because we potentially could be leaving units that could be subject to rent control off the table. But I don't think we have a choice at this point.
Okay, Commissioner Flora?
Thank you very much. Hello. I just had two quick questions. My first was the term permanent exemption. Is that something we only do with single-family dwellings?
Yes, that's a term straight out of the charter.
Yeah. It's been a while. I don't even remember the last year we did it.
If I could just
Yeah.
add one more thing,
Yeah.
Commissioner. This was one of the first major amendments to the rent control law. It happened back in 1984. And whereas prior to that time, there was no specific exemptions for single-family homes, in 1984, the voters amended it to specifically exempt them in certain circumstances.
Okay, and offer a permanent exemption. Okay.
Correct.
And as the sole owner, bless you, as the sole owner, I'm just curious about why an application was even necessary. Maybe I'm not understanding about the original
If I could just
intent.
clarify that, there are two ways in which a single-family home can be permanently exempted under the charter. One is if it was not rented on July 1st, 1984. The other is if it was rented on July 1st, 1984, or the owner or the applicant can't attest to that, then if they have lived there for 2 years as their principal place of residence, then they can apply to the board to have the board recognize it as being permanently exempt, which is what occurred here.
Okay, that's very helpful. Thank you.
Commissioner Trosas?
And again, just back to my, I think, previous train of thought, I understand what the law is and I understand what the voters decided. I think that given the current climate and given the loss of units from our rent control stock, I'm not sure if this is our number one policy priority, but just something that we should keep in mind if this is something that potentially could be threatening future units that would fall under rent control.
All right, if there's no other discussion, I would entertain a motion on this item. Commissioner Trosas? Or
Sorry.
do we have a motion on this item?
Yeah, I also am satisfied with my questions, and I would move the staff report and recommendations, findings of fact, conclusions of law.
Is there a second? All right, we'll take a roll call vote, please.
Commissioner Trosas?
Yes.
Commissioner Flora?
Yes.
Commissioner Phyllis? Yes. Commissioner Foster?
Yes.
Motion carries.
All right, we're on to item 10C, the appeals. Our first one is item number M-0941, 1454 12th Street, Unit E, appellant J. Arthur, sublessor.
Commissioners, Ms. Jenny Arthur subleased her apartment, Unit E, at 1454 12th Street to Mr. and Mrs. Waldron in August of 2013. The MAR for the unit at that time was $11.97, but Ms. Arthur executed a sublease to the Waldrons for a rent of $1,700. The Waldrons have filed an excess rent petition. The hearing officer agreed and found that Ms. Arthur had acted as their landlord and had overcharged them rent in violation of the rent control law. Ms. Arthur has appealed that decision. She argues that the additional rent she charged was for appliances, but the lease makes no mention that any portion of the rent was for appliances. Ms. Waldron never testified that she agreed to the higher rent because she was renting the appliances, and Ms. Arthur herself never provided any evidence that she was collecting additional rent for appliances. Her assertion on appeal that the excess rent was for renting appliances also constitutes new evidence which she did not raise at the hearing when she could have, so the board should not consider it because it is reviewing this matter as an appellate body. Moreover, an additional charge for appliances would still constitute excess rent. landlords may not do an end run around the MAR by charging additional amounts for each housing service. Ms. Arthur claims that the apartment was furnished when she rented it, suggesting that the additional rent was due to it being furnished. Board regulations, however, do not permit any surcharges for furnished apartments. Even if the additional charge was because the apartment was furnished, it would still constitute excess rent in violation of the rent control law. Ms. Arthur also claims that Mrs. Waldron was fully aware that the apartment was rent controlled when she agreed to the higher rent. Mrs. Waldron disputes that claim. Regardless, tenants may not waive their rights under the rent control law. The landlord is subject to liability for rent overcharge when they collect rents in excess of the MAR. Ms. Arthur also states in her appeal that she did not sublease the unit to make a profit and that their relationship was not that of a landlord and tenant. Her motive for charging her purported friend's excess rent is not relevant to the board's appellate review. This is particularly the case here since the hearing officer did not assess her any penalties for willful violation of the rent control law. Ms. Arthur acted as the Waldron's landlord. She charged them in excess of the MAR, therefore she is liable for a rent overcharge. Finally, Ms. Arthur states in her appeal that she is surrendering the unit to the owner and that she lacks the finances to reimburse the Waldrons. Should she surrender the unit back to the owner, or if she's already done so since the decision, the Waldrons will not be able to recover the excess rent by withholding their rent, but Ms. Arthur is still liable for the rent overcharge she collected, and the Waldrons could pursue the matter in a civil suit. Ms. Arthur's financial circumstances are not relevant to this appellant review. Staff recommends, therefore, that the board affirm the hearing officer's decision.
Thank you for that report. Thank you for that report. And we have discussion. Nicole Phyllis has the first spot in the queue.
I'm ready to move the report. No.
Okay, thank you. And I have a clarifying question and a bit of a discussion item, and we'll return to that.
Okay.
So I'm next in the queue. No, we have no speakers on this item. So a while back, we had a landlord couple come and during public comment or something, opined that the rent control board seemed to do nothing when their tenants were subleasing their units for more than the MAR. And, in that particular case, there was no case before us and nothing that fell under our jurisdiction, so we could do nothing about it. However, this is an example of a case where the board does have jurisdiction and potentially can and will tonight do or not do something about it. And that case is when the third party, the sublessee, brings an action. That is when we do, in fact, have cause to do something one way or the other, and we have executed an entire hearing about this, and we're going to hear it tonight. So I just, for the interest of the public, when landlords do have concerns about these things, it has a lot to do, am I wrong, right or wrong, with the language of their own lease that they gave to a tenant, what it does and does not say regarding subleasing, and also that it can become an issue before the rent control board that someone not be paying in excess of the MAR if, in fact, the sublessee brings an excess rent case. So I'm glad this came up as an example of what the board can do. Commissioner Trosas.
I would agree with that, and I also wanted to state on the record, we are here to enforce the law in a manner that we see as consistent and fair with the legal interpretation. And I think that I know often landlords feel as though they are getting the short end of the stick in many of our decisions, but I just want to say I know that there are bad actors out there that are tenants, and irrespective of intent and motive, what happened here is that there was a tenant who charged more than they should have in excess of the MAR and collected it. And to me, it doesn't really matter. Of course, I've read all of the underlying documents. he said, she said, et cetera, back and forth. But at this point, to me, it doesn't matter that that is illegal. You can't contract around the law. And I'm very disappointed to see this type of behavior. We know it exists, and I don't think that we take this lightly at all. So I'm prepared to support the staff recommendation.
Thank you. I wanted to add one last thing. I was dismayed to see that there does seem to be a process temporary out of our process, of our jurisdiction, of administering this couple, these tenants, the refund, if you will, to which they are entitled. And it's because, for the public's information, that because there's a middle party who was the sublessor in this case, it appears from the staff report that the tenants won't be able to recoup the excess rent in the traditional manner that they normally would, because the original landlord was not a party to agreeing to this higher rent level. And staff, are we correct in thinking that the tenant, that their only recourse is private litigation?
If we don't actually, I don't know if Ms. Arthur has in fact surrendered her apartment to the owner, but if she has, then that would be correct.
And will this body be advised of that? Will the agency be advised of that? Since we would be in charge of overseeing whether or not the landlord paid it back, would we then be notified if that changed?
We would be advised if Ms. Arthur actually reimbursed the parties here, the Waldrons, because then they could she could ask for a compliance of this decision. Otherwise, we would not necessarily be advised.
Thank you. Commissioner Flora?
Yes, thank you. What would the Waldron's status be in the eyes, or in under the law? What would the status of the Waldrons be once Ms. Arthur turns the apartment over to the landlord? Can the landlord consider them in any way, shape, or form unlawful tenants? Can he consider them a new tenancy in some regard and go to market rate? I'm curious about their the vulnerability to the Waldrons once the apartment is turned over.
Two comments. One, I would prefer not to even get into that because it has no relevance to the decision of this case. And while I know that the board members can exclude irrelevant things from making their decision, it's best to have a clean record. So whatever the board decides, it's decided very obviously only on the relevant facts. But I can also tell you that we don't have enough facts, even that we are aware of, to know what the relationship between the parties is. So,
all right, Commissioner Trosis.
I would like to also add another point. Is there any way that we can direct staff to come back with recommendations to deter this type of behavior in the future, where there would be some sort of punitive aspect for tenants who engage in this type of behavior? I think I know what you're going to tell me, but from a policy and regulatory standpoint, I do not find this acceptable, and I'd like to do anything within our power to deter this behavior.
It is absolutely impermissible for the board to impose punitive damages.
Well,
but
what about what about preventative?
If I could add one thing to you that may address your question, Commissioner. In this, what is available to the hearing officer are penalties for willful violations of the rent control law. The only reason that it wasn't assessed here because there is a cap of $500, and that cap is either first you assess the interest, and if there's anything left over, then if there's evidence that would support a penalty, then the hearing officer can issue a penalty. Because the interest here exceeded 500, that was not done in this case. So there is an ability to assess a penalty in circumstances where there are willful violations of the law.
I would like to look to see if that's still appropriate, and also, again, be a little bit creative in any sort of disincentivization we can do towards this type of behavior.
Thank you, Commissioner Terosis. Commissioner Phyllis.
So I'm ready with a motion, but I would like to point out that the aggrieved party here was not the landlord; it was the sub-lessee. And again, you know, while I think it's important to convey to the public, you know, that we are sensitive to both the interests of landlords and tenants. You know, in this instance, the party that's harmed by an excess rent is the payee, right? So it's never going to be the landlord. The landlord couldn't have initiated this litigation. I mean, it just, like, the landlord couldn't have done it because the landlord doesn't have standing to do it because the landlord wasn't paying rent. And so I think that it's important that we be precise about to whom we're responding and on what basis, because we're really responding to what is the maximum allowable rent, who charged it, who paid it, and that's it. I mean, that's really the scope of the inquiry. So with that, I'm ready to move it.
Are you making the motion?
I'll move it, and if there's discussion on it, then yeah. So I move the staff report.
Can I just respond to that comment?
And after Commissioner Flora, who's next in the queue.
Well, I'd like to second it.
Okay. Do you?
But we can still have discussion.
Yeah.
I just
I'll second it, and then-
to respond to that.
No, that I wanted to second it, and then I still did want to speak.
Oh,
Yeah.
okay. Todd doesn't.
My comment, I'm sorry I didn't get in ahead of Commissioner Phyllis because I wanted to go back. I'm less interested in exploring penalties on people who are going to claim they can't pay them than I am in preventing Miss Arthur from having done this in the first place. I mean, this is a woman that clearly thinks she's done these people a great favor. But if she'd known she couldn't even change their rent from what she was paying to begin with, we might not be here today. Mm-hmm. So I'm less interested in penalizing and more interested in preventing.
Right.
So I would ask the staff, when they're being creative, to think of what are ways we can prevent this from happening. Are there for buildings that allow a subleasee, are there protocols to follow that if they'd followed them, they would have found out, oh, I can't do this. Oh, well, I guess I'm just going to be able to collect my regular rent from my friends. You know, that kind of thing. Thanks.
Commissioner Terosis.
I absolutely agree, and I think the saying is, what is it, an ounce of prevention is a pound of cure, or something to that effect. I think we need to be proactive in the measures that we're taking to prevent this type of behavior. To answer Commissioner Phyllis, while I do agree with what you're saying and I take your point, I think that it doesn't help anyone to further this type of behavior. I think that it's sorry, I'm just trying to gather my thoughts. It's a nuisance for landlords to have to find a new tenant, and we have landlords who now have to find a new tenant because their tenant engaged. No, the tenant can't pay. She's surrendering the unit. This tenant is surrendering the unit. Now the landlords have to incur the cost of finding a new tenant. I mean,
They're staying.
we don't know. No, in any event, I'm getting to the point that I don't think that we, even though you're saying that, you know, the landlords aren't really affected in this situation, I have to disagree. I think that it doesn't look good for anyone to have a tenant who's subleasing their unit to a subtenant and then doing so in violation of the MAR. Although we don't have any sort of there's no legal relationship. I don't think that we should continue this type of behavior, which is why I think from a policymaking perspective, we're here as a policymaking body, not just as a quasi-judicial body, to, like Commissioner Flora said, to prevent this type of behavior. So I would just say that I would like to see what we can do to prevent it.
May I
So
respond, because it was to my comment?
that's fine. Commissioner Phyllis.
Thank you, Chair. So, you know, I understand that we do sit in a quasi-judicial and in a policy-making posture, but in this instance and for this agenda item, we are sitting in a quasi-judicial capacity, and we need to be really careful about being precise with the record and making sure that we're absolutely clear about limiting the scope of the inquiry. And I think we have to be careful. For example, when we say things like, well, now we know that the landlord has to go and find a new tenant. Well, we don't know that. And two, the sublessee who was already paying in excess of the sublessor's MAR could very well assume the unit for the price at which he or she is paying. Do you see what I'm saying? Like, that is not what's before us. And I think that, perhaps the best, what I've heard, I think is like a good recommendation is making sure that there's public information available to tenants that, you, just like your landlords, can be on the hook if you are charging in excess of the MAR. And really, that's something that started up when we were talking about Airbnb. That's, why Airbnb was so, I think, that really was incredibly frustrating to landlords, because you have, real disruptions going on in these buildings, and you have tenants who are kind of just flagrantly charging way in excess of the MAR. And in that situation, I think we did try to make significant policy changes in conjunction with council, to address them. But, I want to make sure that we are conceptually kind of keeping those two things clear.
And I think that point has been made. Commissioner Phyllis, thank you. So I'm next in the queue. I would like to direct staff to add this topic to upcoming tenant forums in the future as an educational opportunity. We could also entertain the notion of perhaps annually or semi-annually reassessing what is on the info sheet as far as an outreach and educational opportunity. Perhaps a note like that could be added. And the last thing I'd like to say is that to both of your points, I think we are clear on what issue is before us tonight, and that it starts with lease language between a landlord and the first tenant. And the only reason it's before us is because an injured payee has brought a case. And if no one has any other discussion, I say we move ahead with the vote that was made and seconded.
I actually want to clarify, we're not even here because there was contractual privity between the tenant and the landlord. That is not before us. It doesn't matter if the tenant was in violation of the lease or not. The tenant could have been subleasing it in violation of the lease, and that would not matter. The sublessee could still come and bring an action. Then maybe the landlord could go after their original tenant, but all of that stuff doesn't come before us. The only stuff that comes before us is, are they paying in excess of the MAR? And who's paying in excess of the MAR and who's charging?
Agreed. Let's move ahead with the roll call vote.
Commissioner Phyllis.
Yes.
Commissioner Trosis.
Yes.
Commissioner Flora.
Yes.
Commissioner Foster.
Yes.
Motion carries.
All right, we are on to item C2, that is D-4918-125 Washington Avenue, Unit A, appellants J. McCrate and M. McCrate tenants. Appeal of hearing officer's conclusion that lost housing services warranted rent decrease, floor covering, carpet. Can we have the staff report, please?
Commissioners, Janet and Michael McCrate have lived in Unit A since 1992. They filed a rent decrease petition, and the hearing officer granted them rent decreases for multiple items, including $200 for the condition of their flooring. What the McCrates have taken issue with is the fact that the hearing officer stated that the decrease would remain in effect until the owner provides properly finished flooring, either by repairing or replacing the current hardwood floors or by installing a new carpeting of a neutral color. First, the McCrates attached to their appeal new photographic evidence of the building exterior. These photographs were not submitted to the hearing officer, which they could have been through due diligence. And because, again, the board is reviewing this matter as an appellate body, it should not consider these photos in making its decision. Also, in their appeal, in paragraphs 6 and 7 of their appeal, the McCrates make statements about the inadequate cleaning of the common areas, the abundance of berries from a fig tree, and the stains that these berries would leave on their previous carpet. All of these statements are new evidence, which neither Mr. or Mrs. McCray testified about during their hearing, and the board should not consider them either in reviewing this appeal. As for the substance of their appeal, the law is clear that the housing services of any tenancy is set when its initial base rent is established. The McCrates are a pre-99 tenants, so their base rent was established in 1978, and their housing services must necessarily, therefore, mirror that of the 1978 tenant. The 1978 tenant had carpeting as flooring. Although that carpeting was removed by the time the McCrates moved in, the flooring housing service was and is carpeting. That is why the hearing officer stated that she would reinstate the decrease for this one item if the landlord either repairs the current hardwood floor or installs new carpeting. The McCrates clearly prefer to keep their hardwood flooring, but the hearing officer's findings on how to comply with this item is fully supported by the law. Staff therefore recommends that the board affirm the decision.
Thank you. And before we get to public comment, I just wanted to say that I am familiar somewhat with this address, and I just wanted to make the point that a constituent let me know as a public official that they knew of a neighbor who had some problems, and I did simply direct them toward the agency, and it turned out to be this case, but I was never familiar with the complainants or had any further details about the case, and I just wanted to make that public up front. And we do have 2 requests to speak. First, we have Michael McCrite. If you could approach. You've requested 5 minutes, and as a party to the action, you have it.
Thank you. To keep the babbling down, I'll just read my prepared statement. Good evening. We're asking the board to modify the administrative decision and reverse the staff recommendation not to accept the evidence based on a couple of reasons. Number one, the relaxed formality in the administrative hearings, the online hearing preparation information that we read. Question number 4 states a rent control hearing is not as formal as a hearing or trial in court. And as laymen, we were offering evidence as the situations arose and had no reason to argue against carpeting other than to make our objections known at that time of the hearing. And because of the stated decrease in formality, we assume the rules of evidence would not be as strict. And secondly, our expectation was a yes or no ruling on the hardwood floors. Because the petition ruling by the hearing officer included an outcome we didn't seek, the carpeting, our appeal offered many reasons we originally objected to the carpet at the hearing when it became clear that the carpet was an option for the landlord. And we view these reasons as clarifications of our original objection at the hearing and not new evidence. And particularly of item number 5 of our listed reasons. And also, the landlord installed the carpet after receiving the notice of appeal and before the Rent Control Board's decision on the matter. He sent us an email scheduling the carpet installation just hours after receiving the notice of appeal, and we continued to object to the carpet and informed him we were not waiving any rights while awaiting the board decision. And finally, we want the carpet replaced and repaired with refinished hardwood floors. That's what we contracted for when we began our tenancy, and it was a desirable amenity in our decision to take the apartment in 1992. We had no knowledge of the 1978 Registration of Services regulation and had no reasonable cause to ask for it when we moved in originally. Furthermore, we were not informed of the regulations by the previous owner, and when we were considering the apartment, we were simply asking to get what we're paying for. The hearing record will show that we were willing to bear the entire cost of refurbishing the wood floor. It also shows that all the other units in the building, with the possible exception of one Section 8 unit, which we don't have that information, all have hardwood floors. And the units with market rate MARs have refinished wood floors, and the others do not, including ours. And the landlord decided to take the authority of this board into his own hands and install carpet before the matter was ruled upon by the board. And we respectfully ask the board to make repairing and refinishing the hardwood floors a condition of restoring the rent. And if the board chooses to allow the carpet to remain, we ask that a permanent reduction in the rent be granted to compensate us for the lost value and enjoyment of the flooring for which we contracted at the beginning of our tenancy in 1992. In addition, we also asked the landlord be directed to repair the termite damage under the carpet. And that's all. Thank you very much.
Thank you for your comment. Next is Mr. J. Marcani. You've requested 3 minutes.
Well, with your indulgence, I might need more than 3 minutes, but I'll try to be as
You are entitled to up to 5 as a party to the matter.
I would also try to read my statement.
Well, just a moment, please. So, in the rules of the chair, it did state that that party or appellant.
I think that maybe the notes that you have are incorrect, and it's 5 for the appellant and 3 for the other party. If you'd like to extend that, you certainly may.
Why don't you get started, and we'll take it from there. For now, it's 3 minutes.
Well, my position is that the tenant request should be denied because it does not introduce any new evidence or new information as to the presentation at the hearing. It's also based on false information. First, Janet and Mike McBride, statement 1 to 5 are actually false. Rent control record of 1978 shows that the apartment has carpet in it. In 1997, when I inspected the building to see what's the condition of the building, almost all the units have carpets in them. And when I asked Mr. Mike McBride about if he has any question or concern about his apartment, he said none. It's a cheap rent, and I'm very happy with it. And in 1999, I took possession of the building. Apartment A has a carpet in all rooms except for the kitchen and the bathroom. 4, tenant Estable, which I submitted on this month on the 10th, which signed by Mike McBride, indicates that he's very happy with the apartment condition, with no exception. At that time, the apartment has carpet in it. The lease was basically modified and dated on March 1st, 1993, and the condition was attached to it. And there was a lease in existence, but Mike McBride was part-time manager, and somewhat that lease disappeared when I received the papers from the previous owner. Basically, it's in the Estable, item 6, 7, and 9, which
Sir, if I may, we need to stick to the facts that are in evidence, and you may not testify at this point in any way, shape, or form as to new information you may not present new information at this time. So if you have a comment about the facts that are in record prior to the appeal date and this hearing, you may comment to that.
Well, the fact that there is a written record shows that the apartment has carpet in it before, and it has carpet when I took possession of the building. That is pertinent to the case at this time. And I don't know why I cannot present it.
This body is not allowed to hear new information or new testimony outside of the record. There is a process in place for that, and the time both for instance, for your photographs or anything else would have been before and not after the date of this hearing, and not at the hearing.
What I'll conclude is that the apartment on the record has a carpet in it. When I took the possession, it had carpet in it, and they had no objection over not having a carpet for 20 years, till last year. So I see no reason why the carpet should not be accepted.
Okay, does anyone have questions of the speakers? Commissioner Trosas, is that an indication you have a question? Or Commissioner Flora, did you have, you're first. Okay.
I have a question, and maybe it's for you or the McRae's. when they moved in, was there a hardwood floor, and was that included in the lease?
You should come up to answer the question.
Is that part of the record?
A clarifying question.
Yeah, I believe it is.
I think that was part of the hearing record and part of the appeal, that when we moved in, we had hardwood floors. The previous owner we had a small child that was born in 1996, who's not Columbia, that I never get tired of saying that. But we had a small child, and he was slipping with the socks and, busting his head, and so the previous owner put in some inexpensive carpet as an interim, to keep, with the understanding that when the child grew up, we would remove the carpet.
The question was just about at the beginning.
So at the
of your
beginning,
lease.
there was a hardwood floor.
That is correct.
Thank you for
And was the carpet then made to cover the pre-existing hardwood floor?
Yes.
And what is the proposed remedy, or have you already put carpet, and does that involve removing or stripping away the current hardwood floor that exists?
The remedy that I would like would be to have the carpet that he put in removed and have the existing hardwood floor refurbished, repaired, and refurbished.
Okay, so you put in carpet over the hardwood floor or instead of the hardwood floor? What's the current state of the over the hardwood floor? Okay, thanks. That's it.
Is there another clarifying question, Commissioner Flora?
Yeah, but I want to keep my turn on some other things
Okay.
too. I know this is just my first question, and they can remain there or not, and that is the floor is still in the state of disrepair, correct?
According to the report.
New carpeting,
He put carpet.
carpet has been put on it.
Prior to this decision?
Yes.
Yes.
Since the decision.
So since the decision,
Tonight's decision.
you guys had
We had the hearing, we received the decision, we appealed the decision, the carpet was installed, and now we're before the board arguing.
Okay. Yeah, that.
appeal.
Are you ready for your
Yeah.
discussion portion of the?
I have a big question. It boggles my mind why maybe it wasn't.
You can be seated.
Thank you. You can be seated. At some point.
Thank you. You may be
At some
seated.
point during this process, would it have been appropriate for our staff to just say, "Hey, you know what, guys? Maybe you should go to mediation," or "Hey, maybe Mr. McCrate maybe the solution could be he pays the difference between the carpet and the hardwood floors." I mean, I feel like if something like that had been encouraged, I mean, if the floor had not been repaired, we could still be talking about maybe the McCrate simply paying the difference between carpet and hardwood floors.
Sounds like Mrs. Regalado would like to.
At what point didn't anybody
respond.
make that suggestion?
We offered mediation, and I'd have to check the record to see if mediation was declined, but mediation is always offered before the hearing.
Yeah. Nobody thought about the pay the difference thing, huh? All right. Well, here's my next question. I mean, 'cause the carpet's already there. I thought I had a good solution in mind if the McCrates were willing to just pay the difference, but the carpet's already there. Okay. Page 31. This was in January. What month did we raise the minimums? So on page 31, they're getting we don't have $5 minimums anymore. I think our minimum was raised to 10 or 15 when we raised the minimums on rent decrease.
I would just, before even addressing that, none of those issues are before the board tonight.
But I'd like to know why this is only $5.
Then we should talk about that outside this hearing.
All right. That's it from me.
Anything else? Okay. So I'm next in the queue. I have a couple of questions of staff and a couple of comments. I see a lot of inconsistencies with this property, in the evidence that's in the record, with the back and forths and the he said, she said. You know, on page 16 of the record, he stated that the tenants, that he would consider leaving the floors, which he is using as a bargaining chip, it appears to me, if the McCrates would sign a new lease or give him a copy of their old lease, which he seems to claim in the record they've done away with on purpose for some nefarious purpose. You know, we've often seen withholding of repairs or withholding of upgrades when every other unit in the building's been granted upgrades at whomever's cost, and tenants in long-term tenancies trying to improve their homes and the landlords sometimes not allowing them, I believe personally, simply out of an effort to get them to want to leave, instead of having a more habitable home like perhaps their neighbors have, even when they've offered to do it with licensed contractors as per the law requires, and the correct permits and at their own cost. So the fact that in the original testimony and in the appeal writings, that's so much back and forth and consideration between hardwood floors, carpet, it's almost like extortion. It was like bargaining. Well, maybe I will if you do this. It's that type of behavior that that our presence up here as a board, some of us have run on platforms of trying to prevent such unequal treatment of tenants that are otherwise under the same law. And I do understand from the reading of the law that because to the letter of the law, carpet was listed on the 1978 registration of the unit, I find a really big disconnect, and I wonder if staff can bring back a discussion item for another month. And I do realize it would take a potential change in the charter. But if it walks like a duck and quacks like a duck, I'm going to think it's a duck. So if I come along in 1990 whatever and sign a lease, and the lease says I get a parking space and a washing machine and dryer and hardwood floors, I think that's what I'm getting for the consideration fair market value that I'm offering or that's being rented for. And then if you come along much later and find that just because something got ruffled up, you all of a sudden are being reverted back to some ancient style or thing you never signed up for and never wanted, I don't really see, it's not like it's in the public section of the newspaper. It's not like, you would have to make an appointment and know to come into the Rent Control Board and avail yourself of an archaic record, if in fact it even is complete, and find those original amenities. Now, I do understand that our staff does a great job if in fact someone does want to come in and look it up. But to the McCrate's testimony, they wouldn't have even had any way of knowing at the time of lease signing, because there's no language in private leases to where we would know as a public body that people are being educated to this art. And to finish, it upsets me that post-99 tenants and pre-99 tenants are separate but equal. I'm uncomfortable with the fact that they're treated differently under the same charter. And I understand it's because of Costa-Hawkins, but I feel that when someone signs a lease for something and they give consideration for it, I just find a big disconnect, and I would love it if staff could advise. I mean, I understand what the law says and what's before us tonight, but is there something we could discuss at a future meeting to discuss a potential update in some way to the charter in regard to this matter? Does staff have?
Well, I would just make one very brief response, which is that it's not accurate to say that in entering into the lease that they bargained for something other than what the housing services were in 1978, even if they thought that they were doing so, because the rent was what it was, and that rent was based on those housing services. And so the idea that they're involved in a transaction in which they get to decide these things is factually inaccurate.
I understand that.
So, I mean, just as
But what if what if the owner is subsequent, a subsequent owner after 1979, and they think they're leasing a unit with hardwood floors? It just seems.
It doesn't matter what the people think, because if that were the case,
I think private property owners would find that an interesting concept.
If that were the law, then the limitation on the rent at that date would also not apply if the parties thought something different, and that's simply not the case.
I understand. So I'm still asking staff if we can discuss at a future date, perhaps an education. I don't know. I'll withdraw my question for now. And Commissioner Phyllis is next in the queue.
So I understand the frustration here, and I think, you know, what we're all struggling with is the fact that there seems to be a fundamental unfairness when you have someone enter into a contract expecting that there are certain terms that are going to be honored, and those terms aren't in fact honored, and then the body that presides over the rent decrease petition says there's nothing we can do because 1978. But the fact that we cannot do anything does not mean that the tenant doesn't have any recourse. The tenant, if there was evidence of this being a term in the lease, could sue in a civil court, which is, you know, if you have a contract and you have a term in a contract and the term of the contract says you have hardwood floors, then go after them in court for breach of contract, for not, you know, that's that. So what I'm trying to say is we're bound by the charter, and, you know, we are a board of limited jurisdiction. And in the interest of having a clean record, and in the interest of really honoring the power that the people of Santa Monica gave us when they passed rent control, I think we have to be hyper vigilant of exceeding that jurisdiction. And as much as we want to, as much as, you know, this is a frustrating situation because it does feel unfair, right? It feels so unfair that they moved in with a hardwood floor. They had it their entire, you know, tenancy except for when they had a small child. I mean, like, that's frustrating that we can't do anything, but it's not our job to do anything. And there is a court that could do something. So that's where I'm at.
Thank you, Commissioner Phyllis. Commissioner Terosas.
I think Commissioner Phyllis read my mind. I was going to opine that as a pre-99 tenant, you, again, have to look at the services that were established when the base rent was established. And that's unfortunate because I hear everything that's being said about thinking that you're contracting for hardwood floors and then finding out that you have that replaced with carpet. To me, hardwood floors are an amenity that I would want to contract for if I was renting an apartment. But like Commissioner Phyllis said, that's what we have civil actions for. That's why we have contract law. It's not under the jurisdiction of the Rent Control Board, but it most certainly could be under the jurisdiction of a civil court to order specific performance or anything of the like that they would deem to be sufficient given the contract in place.
Thank you, Commissioner. Commissioner Flora.
Yeah, just to wrap up, page 32, it indicates that there is a $200 decrease for the hardwood floor. So we have done something within what we can do.
But that's not once
no.
that was
And
repaired with the carpet, that's
right.
okay, but could we? So here's my question. Could we? Oh, I thought I had a good idea, but I just thought it through. Never mind. I was gonna suggest that if now that that's repaired, the $200 is off the books, correct?
That there has not been, it has not come before the hearing officer yet as to assess as to whether to reinstate the rents.
Okay.
If the landlord believes that he has come into compliance and he has done what the decision says, then he can contact the hearings department, and there is a process to assess that.
All right, I'm going to throw out my question anyway because I've said much dumber things on this dais than this. Given that fact, are we within our right as a board to accept the recommendation of staff on this decision with one, and I'm not suggesting we do this, I'm not making a motion, I'm simply asking the question, with the ability to have one amendment added, and that be that the hardwood floor, $200 hardwood floor amount be considered a permanent decrease? We couldn't do that? Okay, thank you.
Commissioner Phyllis.
So I just want to, you know, council said this much more articulately than I do, but there is a reason why we look to the amenities that existed in 1978 for a pre-99 tenant. And that's because those rents are regulated pre-Costa-Hawkins, which means that they were not subject to vacancy decontrol. They were not subject to any of the things that we kind of as modern rent control people understand rent control. And so the fact that those rents were much more tightly controlled than things are in post Costa-Hawkins, I think is the reason why you have to look back to the 1978 amount, and why, you know, even though it feels unfair that they basically had an amenity that was kind of beyond the scope of what they originally were benefiting from in these these 78, this pre-99 world, that's what their rents were based on, right? Like, that's what the increments of the rents were based on, and that's why their rent was likely as suppressed as it was. So we have to be thoughtful kind of about like the history of these units, especially in the pre-99 world. And so, I think it's really clear. I don't mean to belabor the point. I'm ready to move the report.
Commissioner Flora?
I was going to do exactly that. Yeah, it's I know how this one makes us all feel, but nevertheless, I'm going to move that we adopt the staff recommendation that the hearing officer's decision finding of facts and conclusions of law in denying the appeal.
Do we have a second? All right, a roll call vote, please.
Commissioner Flora?
Yes.
Commissioner Trosis? Yes. Commissioner Phyllis? Yes. And Commissioner Foster?
Yes.
Motion carries.
All right, we have another appeal on item 10C. It's D 4930 1448 Princeton Street, Unit 2, Appellant R. Wade, tenant. May we have a staff report, please?
Commissioners, Ms. Robin Wade has lived in this unit since 1978. She filed a rent decrease petition, in this case alleging various maintenance conditions. The hearing officer awarded her a $20 decrease for the condition of the weather stripping of her front door. But the hearing officer denied rent decreases for most of the conditions in her petition. She has appealed the denial for some of them. The board reviews this matter as an appellate body, so it may overturn a hearing officer's decision only if it's based on factual findings that no reasonable person would understand to be supported by the evidence, or on legal conclusions that are clearly erroneous. This appeal raises no claim of legal error, and the evidence reasonably supports the factual findings supporting the hearing officer's denial of the items contained in Ms. Wade's appeal, except for one item which was not even included in the petition. That item, water that is unsafe for drinking because of the condition of the pipes, was not an allegation that was raised in the petition, and due process precludes the board from granting a decrease for it on appeal. As for the other items, Ms. Wade alleges that the owners are not letting the cable company fix or replace her cable TV line. The owner has stated that he's willing to allow them access, but requires Ms. Wade to sign a release form prior to authorizing the work. The record is clear that Ms. Wade did not have cable TV service when she moved in, so it's not a housing service of her tenancy. Therefore, a rent decrease is not an available remedy for her dispute with the owner about the cable company's access to the building. If I could just correct what I said, the record is clear that she didn't have cable TV service as a 1978 amenity. To the extent that the housing service is not cable TV service itself, but the tenant's right to maintain and install such a service by having a cable TV repair person enter onto the landlord's property without any form of indemnification or release, there is also no evidence of the existence of such a housing service. Ms. Wade also argues that she should get a decrease for the condition of her dishwasher because it's old, it lacks available replacement parts, has massive corrosion, and has broken racks. The owner installed the current dishwasher in 2010. At the hearing, Ms. Wade alleged that someone came over to repair the machine, said that the machine was old, and that it cannot be repaired because replacement parts are no longer available. That statement was hearsay, and she didn't provide any evidence to corroborate it. Neither the hearing investigator's photos nor the video clips show any broken racks, and the rust in the machine in the photos that are in the record appear minimal. Given that record, The hearing officer's finding that the condition of the dishwasher did not warrant a rent decrease is supported by the record. There is no evidence in the record that shows this finding to be manifestly unreasonable. Ms. Wade also argues that she should get a decrease because the owners damaged the frame of her inner door, which makes it hard to lock. The evidence shows that the hearing investigator watched Ms. Wade close the door a couple of times without any problem. Ms. Wade testified at the hearing that the inner door's operation has improved since the Westside Center for Independent Living installed new handles. She said that the door is now okay. She didn't mention any damage to the inner door frame in her petition or in her testimony at the hearing. The allegation about the inner door frame is therefore new evidence, which the board should not consider because it was not provided to the hearing officer, and it could have been, and it wasn't done, and that was not done. The hearing officer's finding that the condition of the doors did not warrant a decrease is reasonably supported by the evidence that was actually submitted into the record. Most of Ms. Wade's appeal, however, concerned the alleged decrease in management services. Ms. Wade raised the same issue in her last decrease petition. She did not provide any evidence to support the decrease at that time. Ms. Wade has filed 10 decrease petitions during the tenure of the current ownership. No other tenant on the property has filed any. The relationship with her owner appears fraught with miscommunication and acrimony. The manager testified that Ms. Wade has a habit of complaining about a problem and then calling back repeatedly before there's even time to address the problem. The problem in effective communication between the parties appeared to have improved when Ms. Wade had a social worker who acted as a liaison. That person is no longer involved and communication appears to have again deteriorated. But it's also important to note that from the record, most of the alleged problems raised in her petition that could be verified, things like cockroaches, plumbing, and a wobbly dishwasher frame, were addressed by management during the course of the petition process. It's also significant that the majority of the issues that Ms. Wade has raised in her previous petitions did not warrant a rent decrease. Given that history and the evidence in this record, the hearing officer found that Ms. Wade has failed to show a reduction in management services that warranted a rent decrease. In her appeal, Ms. Wade did not point to any evidence in the record that showed that the hearing officer's finding to have clearly been in error. And the board therefore should not reverse her finding on that issue either. Staff therefore recommends that the board affirm the hearing officer's decision.
Thank you for that report. If there are no questions of staff, we do have a request to speak by Ms. Robin Wade. You have requested 5 minutes.
Can you hear me okay now?
Yes.
Hi. Oh, it's going to be hard.
Maybe bend it down. Bend the microphone down a little bit,
way?
please.
Are you okay this way?
Yes.
Oh, okay. Whoa, okay. I'm here because I need to be heard. And I don't feel like I've been heard. And, you know, I think it's important that I came here in particular, because I think if I'm here, you're going to listen to me. And I speak the truth. You know, I don't lie. I don't tend to lie. I don't tend to minimize things. And I've been at this apartment complex for almost 40 years next year. The owners, the Toms, took over the property about 31 years ago. When they first moved in, they damaged my screen door. I asked them to repair it, and the response was, "That's your problem."
Ma'am, I would just remind you, just a moment, please,
Okay.
that your comments should be limited to the evidence that is in record in the current staff report and in your hearing record.
It's very hard to summarize, you know, what's been going on for a long time. But let me go step by step with you then. The dishwasher, okay? It wasn't just the dishwasher frame, okay? It was there, as I said before, I couldn't bring the racks here to show you all that they're broken. I did hire a licensed company to come out 2 years ago to look at it, and it charged me $65. I asked him to please put down the evidence on paper. Why he didn't do that at the time, I don't know, because I know that was important for you all to see that. So no, it has not been fixed. You know, unfortunately, I was told the stuff that they put in is very substandard, and, you know, it doesn't last forever. Things have to be replaced. In terms of the cable lines, everyone in the whole building has access to cable lines. Everyone. This is common services for everyone. Yes, I was offered to have paper filled out, you know, to supervise work. I'm not qualified to supervise work for cable installation, and they have, you know, insurance. Time Warner has insurance. They even offered to update the whole building and repair it. But they said no. You know, it's like taking your car in to be repaired, and you're supposed to be responsible if they damage your car and supervise it. Well, you know, I'm not qualified to supervise anyone's cable service, and since they have insurance, they were gonna, Time Warner was gonna pay for it, but they refused. Let me see. In terms of responsiveness, in terms of managerial services, it's very hard for me to sum this up. Am I irritant? Do I bother people unnecessarily? No, I do not. If there's a problem, I say something. I do not generally talk to David Chu, the owner, the manager. If it's been many years, I did ask for some repairs a year ago. It took them a year to fix the weather stripping, a year. You know, if I ask the owner a question, she says, move. You want something to be fixed? Move, leave. I'm repeatedly harassed to move. And, you know, it's been very uncomfortable to live in a situation where you pay rent on time. I've had, you know, a few problems in almost 40 years with my rent. And, you know, it's very uncomfortable where, you know, I know I don't have a lot of money. A lot of people in the building maybe have money to repair things themselves. Well, I don't. And, you know, maybe I speak up because I need things to be replaced and repaired in a timely fashion. You know, not something that takes weeks, years, and, you know, not giving a fake phony phone number to call, and they don't answer the phone or slam the door in your face or whatever, or being abusive, and sorts of ways that I don't want to discuss in this hearing.
Ma'am, let's stick to the
I understand.
the facts and
But
evidence.
The fact is that the managerial services are not there. I can't count on the manager to call back.
Thank you, Ms. Wade.
But anyway,
Ms. Wade, that's
thank
the
you
extent of
very
your
much.
time. Thank
Okay,
you so
thank
much.
you.
Commissioner Terosis.
Thank you, Ms. Wade, for your testimony. I assume the landlord is not here to make a comment.
No one else has placed their name in for public comment.
Okay, then I'm gonna start the discussion. So effectively, in my analysis and my reading of the facts, and then again in hearing from Ms. Wade, we have to remember that we can't grant a decreased petition for something that was not raised in her petition. I feel like there are some facts that are raised on appeal that were not raised in the petition, and I want to speak to that. It sounds like what I was hearing from the description, it sounded a little bit to me, again, I'm not giving legal advice, like tenant harassment. If there are repairs that are being refused, and comments made such as just leave, I would definitely encourage you to seek advice and counsel of the city attorney and potentially file something with them. Unfortunately, this body doesn't have jurisdiction over that. We just have to look at what's before us, and we have to look at this from a clearly erroneous standpoint. To me, I don't see that this rises to the level of an overturning of the hearing officer's decision, and I would have to affirm the hearing. I would have to move to affirm the hearing officer's decision.
Okay, I also just on a black and white basis, I am also inclined to accept the staff report, and I would entertain a motion at this time if either of my colleagues remaining on the dais would like to make a motion. Is there a second?
Second.
Roll call vote, please.
Commissioner Trosis?
Yes.
Commissioner Phyllis? Commissioner Foster?
Yes.
Motion carries.
All right, we move on to the public hearing portion of our agenda. Proposed amendments to Rent Control Board Regulation 4400 respecting construction-related rent decreases. We have, we'll begin with the staff report summarizing the issue and including any recommendations, and hear from the public afterward. May we have the staff report, please?
Yes. As detailed in more exhaustive detail in the staff report, there are two categories of recommended amendments to the rent decrease process for construction impacts. One category of recommended changes is really just language cleanup. There are some somewhat convoluted verbiage that we've just recommended saying exactly what is already said, substantively, just more simply. But there are a few substantive changes that I understood the board to seek when we were all last here, and then some additional substantive changes that that arose as the result of the way things are actually done. So they're not substantive changes to what actually occurs, but are codifying what does occur in order to make sure that everybody understands how the process works. So I'll go through those things very briefly. The first substantive amendment is in subdivision B, paragraph 1, which requires a tenant to have suffered some actual interference with a housing service before filing a petition. The reason for that is that interference with a housing service is already a prerequisite to getting any kind of relief. Given that no relief is possible until something has occurred, it doesn't make sense to allow a petition to be filed until that has occurred, because the petition is then being filed based upon something that's purely speculative, and the hearing examiner has no authority even to do anything at that point. Moreover, because, as we'll discuss in a moment, the rent decrease, if it is granted from the moment that the interruption with the housing service began. The entire period of any interruption is covered, so there's no practical benefit either to starting a process before something actually occurs, because there's no loss of any decrease that would occur from waiting until the housing service is actually interrupted. The second substantive change is in subdivision C, paragraph 2. Previously, relief could be granted only from the date of notice forward, which is what I was talking about a second ago. This change would say the relief is for the entire period of interference with the housing service, regardless of the date when we give notice. That's also reinforced in subdivision I. Paragraph 4, also of subdivision C, says that all petitions arising from the same construction project at the same property will be heard together if that's possible. That's a practice that the hearings department already employs. There are a few benefits to that. One is that it makes mediation much more productive and much more likely to result in resolution of all of the issues. If all of the parties and all of the issues are out there at one time in one petition, then they can be resolved together. It also prevents a piecemeal resolution of the exact same issue over and over again. It's important to note, however, though, that it says only to the extent possible. Let's say there is a 40-unit building. Again, I don't think that there is such a property in Santa Monica, but let's say there's a 40-unit building with all of the units in a row, and the construction is beginning at one end of the property, and it's going to be a 5-year project, and it won't get to the other end until 5 years later. That would not be in a situation in which it would be practically possible to hear all the petitions together, because the people who aren't going to suffer an impact for 5 years couldn't possibly bring their petition when the people at the other end of the building are bringing it. So this, again, is not a mandate that we hold off on doing things until other people file, just that if it is practically possible to consolidate the hearings, that we would do so. The next substantive change is in subdivision D, which states that if the parties enter into a mediated settlement agreement, that agreement will be forwarded to the appropriate city officials so that the agreed upon mitigation measures can be incorporated into the means and methods plan. It's already the case that if the parties enter into a written settlement agreement, that they can enforce that through a court process as a contract. But given that the city has a means and methods process that can be enforced very expeditiously through code enforcement, this would provide a much quicker and more efficient means of actually enforcing what the parties have agreed to. And it also is, just from a common sense perspective, an appropriate thing to do, because the purpose of the means and methods plan is to put in place means and methods of mitigating impacts. If the parties themselves have said, here's what the impacts are and here's how we mitigate them, there's absolutely no reason why that should not be included in the mandatory things that the landlord is bound to do, since they've already agreed to do those things. The next substantive change is in subdivision E, paragraph 3, which eliminates the statement that the board could file its own petitions on behalf of non-applying tenants. As I mentioned in the staff report, that's not actually a change from the existing law. It's simply a change in the language of the law. Since 2004, it has been clear, as the results of a court decision, that that's not something that we have the authority to do, and we have not been doing it since 2004. So this is just sort of like a phantom verbiage that's in there that needs to be cleaned up. And that is the entirety of the substantive changes that staff is recommending based upon our understanding of what the board, the direction that the board gave at the last meeting in which this was discussed. Thank you.
Did you want to discuss the different recommendations at all, the alternative?
Oh, yes, actually, I wanted to mention one more thing too. Next month, we will be bringing to the board a proposed revision to the appeal process for rent decrease petitions, and this is a rent decrease petition. When we do that, that will affect the appeal process of compliance determinations with respect to these as well. So that isn't in here, but that will be addressed next month. In the staff report, I've recommended 3 possible things that the board can do tonight. One is that it could, well, there are 4 things. One, it's always, of course, the possibility that the board could opt to do nothing. I never list that as a recommendation because that's always a possibility. But the board can adopt the recommendations that we've made in their entirety as they are. Alternatively, if there are relatively minor amendments or even major amendments that we can hash out the exact language of this evening, the board can adopt what has been proposed with whatever additions there are in the actual regulatory language. Or if it's not possible to work out that specific language because it's too complex or too voluminous, the board can give direction to come back at a future meeting with that language proposed for the board to consider. And there's some combination of all of those things that the board can do as well. It's not one of the recommendations that's made, but it's also possible that the board could adopt tonight what we have recommended and ask for further revisions as a separate item in the future. Thank you.
Thank you. And unless there are any clarifying questions, which I'm going to go ahead and assume that a lot of our discussion items will include various points and questions. Commissioner Phyllis is first in the queue to speak. We have no public speaker, no public's comment for this item, so we will go into discussion.
So, in terms of where I'm at, I'm comfortable with actually moving the staff report. I think it's clear and fine. To the extent that we do start undertaking substantive revisions and kind of doing this piecemeal, I think we may benefit from sitting all together as a board. So waiting until Chair Duran is back, in which case, you know, I only because I think on something where we are considering, you know, if we do think that there is controversy regarding any of these proposed amendments, I think it's helpful to sit as a full board. So, you know, I'm comfortable with moving the staff report, or in the alternative, to the extent that we feel like we need to have more laborious substantive deliberation, I would propose to my co-commissioners that we table it until we can sit as a complete board.
I would ask a clarifying question on Commissioner Phyllis's point. One of our options, I believe, is to recommendation number 2, that if we have substantive or too numerous points to discuss, that perhaps one alternative is to discuss some of them now, so that staff could get some clarifying points into next month's rediscussion, at which point Commissioner Duran would be present. And I totally agree that on a substantive regulation change that we should all be present. In the interest of time, though, when Commissioner Terosas first brought this up several months ago, I'm just sort of interested in seeing it continue to move along, and so I didn't know if anyone if you would have any objections to maybe discussing a few finer points, so that in case there's just some loose ends, they could work on that in the interim.
I'm happy to defer, although I do think that we can give staff that direction off the record as well, and that, you know, it may be more helpful to have a full and complete discussion sitting as a full board after staff, has received, you know, and sometimes it's helpful to have these things as written direction, particularly where we're dealing with something like this, where we're talking about line edits and red lines to regulation. I think sometimes the exercise of having a written record directing staff can make the recommendations better. I'm obviously not going to try to stifle discussion. So if my colleagues feel like there's a fire in their bellies to have like a really laborious discussion and then have another really laborious discussion when Commissioner Duran returns, I'm happy to participate in that. But, that would not be my preference.
Well, I don't know that I would like to call it laborious. Really, it's something we're here to do. But to Commissioner Phyllis's point, before we go any further, this staff report was only made available publicly and to us Tuesday. So there has not been a large amount of time for even us who are present tonight to sit with this information. I have my name in the queue next, and I was prepared to go ahead with some clarification points. I would still like to go ahead with my personal 1 or 2 clarification questions, because it might just tie up and quickly get it off the plate for me if in fact I'm incorrect about a couple of my assumptions. But before we engage in that discussion, do either Commissioner Terosas or Commissioner Flora have an opinion that they'd like to offer in regards to what Commissioner Phyllis has proposed?
Sure. I would agree that I would like to table highly laborious discussion until Commissioner Duran returns. A, I think it's important that we're all here, but B, I have not had enough time to my satisfaction to go line by line to think about some of the actual implications of the new wording. Having written many ordinances, these processes take quite a long time, and there are some things I think that need to be fleshed out a little bit better. But I'm happy to give a little bit of direction at this point after Commissioner Foster gives her direction.
I agree. Commissioner Flora, do you have an opinion?
Just that I would encourage us not to take a really, really, really long time.
I agree.
I see there's maybe an appetite. I don't know what else is waiting for us on the August agenda. but
Well, the
I
other
see
the
there's-
other appeal process.
Well, I'm
as
just saying, but who knows
counsel
however many
mentioned.
who knows however many part
How does that pertain to tonight?
just how loaded up are we going to be in August? But what I would say though is I do recognize there's an appetite perhaps not to fully act tonight without our chair involved, but there are enough substantive changes in here, and when you consider what a real issue this is becoming in the city, I really hope August will be the definitive time that we make a final decision. People are waiting for some of these changes to take place, and they're going to help some people. They're going to help some tenants. And so I don't want this to be a 5-month by committee, line by line, legalese to death issue. I've worked with this staff for a long time, and I can tell you that if Stephen wrote this, he knows what he's doing from a legal standpoint.
Well,
but again, I acknowledge that there's an appetite to take enough time for each of us to both think about it more and come back with Commissioner Duran involved. But it just frightened me a little bit when I heard these things take a really, really, really long time. Because you know what? This is the new harassment, guys. This is the new harassment.
Okay, all right,
Yeah.
and just a moment, and to that point, we have raised the concern of speed with which to hear this process, because it was introduced many months ago. Commissioner Phyllis would like a chance to respond, and then we will continue with brief discussion.
I'm highly concerned.
Okay, so I'm going to keep this really, really brief. I think that there are two factors that strongly favor a very, very modest and high-level discussion, and then a very modest continuance of this hearing until August. My recommendation is conditional upon an extremely short timeline, making sure that this can get heard in August. But I think both the public and board members would benefit from having more time to deal with a report that talks about, we're talking pages upon pages of redline, which is, if you're not a lawyer and you're not used to it, I think something that needs to, even as a lawyer, you have to deal with it, and you have to kind of think about it in a very careful way. And, I think all of these factors just favor a modest continuance.
Understood and taken into consideration. So I will try to quickly, since I'm next in the queue, make my point. Tracy, Ms. Condon, would you like to respond to something now, or?
Well, I was just going to say our August meeting is currently quite light. We don't have any appeals, and the time has passed for which we would be processing appeals now. And I think we just have 2 exemptions. So I think we'll bring it back for the August meeting.
Oh, that would be great.
Policy heavy.
And then the appeal process issue.
And the compliance process for the decreased petitions, yes.
And I do agree that some of us had asked, earlier in the week for the public's information, was this in fact related to, in some part, things that were brought up in prior cases that have come before this board in recent months by some of our constituents, in which they questioned the appeals process that the tenant has. And we've been advised that next month we will be taking that up, and that some aspects of this do overlap with that. And there will be some closure of some kind or another on that next month. So with that in mind, I just have a couple of quick items. I would like to see something in, hang on, I gotta find my section numbers here. C, I can't find it. My concern was a definition in here somewhere for practical purposes of neighboring properties that are contiguously owned by the same landlord. I was curious to see that there be some, when sometimes there's less than 6 feet or 5 feet between 2 gangways and 2 window walls, that construction on one property not be utilized against against a tenant harassment situation in an adjoining building that are contiguously owned by the same landlord. So I just wanted to see if perhaps we could get some clarification on that. And then on page
Can I just? Oh, sorry.
sure,
I can
please
hold
go
on.
ahead. No, it's all right. Because like I said, if you can erase it from my mind now, then we don't need to Put it forward.
Well, two things. One, the rent control law, when it uses the word property, includes contiguous parcels under common ownership. So that's already defined in both the charter and we can.
And you and I had discussed that briefly prior to tonight's meeting, but I feel that it's not something necessarily that the public knows or that I personally understood before my time on this board. So I do still feel like it's something that if it's appropriate, I'd just like to see enumerated in some way.
Right. The other thing I wanted to say is you mentioned a concern about harassment. It's important to remember, though, that this regulation can do one thing and one thing only, and that is adjust the rent to equalize the rent with the housing services provided.
Yes, understood.
And
it was a poor choice of words. Yeah, okay. Thank you. And then on page 1 of Exhibit A, item B, I would like for staff to explore something. You know, I've expressed a problem in the past with this 24-hour business that on page 1 of Exhibit A in the red line, on item B, when rent decreases are authorized or reduces or removes the housing services of a controlled unit for a period exceeding 24 hours. I've just personally seen cases where they are 8 and 10 and 12-houred to death. And I brought this up during the other public discussions about this item in preparation for some of this language that you did put together. And I definitely, it's still very important to me to explore the seemingly arbitrary or maybe an outdated hour figure of 24 hours. There are many ways to inconvenience a tenant's habitation in increments of less than 24 hours, and I would like to explore that. And last, just below that, 1, 2, 3. In another case I was researching for this week, earlier in the agenda, it was brought up that if something was that repairs are different when there's something that's voluntarily taken on as a rehabilitation or an improvement versus something that's being repaired due to neglect or due to a deterioration of some kind caused by whatever source. But it specifically mentioned that when there's deterioration due to neglect by owner or landlord, that it is considered a decrease-worthy, amenity reduction for the course of time it takes to do it. So I didn't see that language in this section, and I wondered if it was an appropriate place to include it. And again, this may be something that's de facto, somewhere else in the law. But again, if we're going to take the time and the public scrutiny to outline this exact case of rent decreases for construction, then I wanted to be specific. So those are the only 3 concerns I had. I'm just going to leave it there. I don't need to discuss it. I just wanted to direct staff to take a look at those items. Thank you. And Commissioner Trosis.
Okay. Thanks. And I want to thank staff for coming back with this very well thought out red line version. This is a high priority for me, and I know for all of us. And I know our members in the community are watching and have asked multiple questions about this. Even if I was 100% satisfied with everything I've seen, I think it's really important to me to have a public participation process. And given the fact that we only got this on Tuesday, I wouldn't feel comfortable. I don't see that many members of the public here. I haven't personally heard from that many members of the public. I'd like to hear from constituent groups, landlords and tenants. And I'd also like to hear from code enforcement and building and safety, even if it's just a staff report letting us know that they've been consulted and what their feedback was going forward. That's really important to me. I think it's important that we have buy-in. We are not a city agency. We have to work across agency lines and making sure that this is a streamlined process where they were involved and they've completely bought into this process is and was and remains important to me. So with that being said, I actually think the intent language at the top is really important. I think it's a little bit light. I think this is really where we set the tone. And I know that our counsel here stated that there are definitions elsewhere in the regulation. I'm not sure what the practice is here, but I know typically speaking, when I've done this professionally, there's a definition section at the outset, and I feel like there are some terms in this section that beg further clarification. Like, for example, B sub 1 is a little bit vague to me, and maybe there are points elsewhere in our regulations that better define affected by construction and unreasonable delay, but to me it's too vague. I think if we are to adopt these regulations, we need to have implementation guidelines or something that further speaks to this if we're not going to have a definition section, because if I'm a landlord or a tenant, I don't really know what this means or how it's going to be interpreted by the agency. I agree with Commissioner Foster. You could have 5 days in a row of 8-hour displacement. I think that that's a problem. The period exceeding 24 hours is not the correct threshold, in my estimation. And then in terms of Section C, receipt of information that substantial repairs, rehabilitation, or upgrades are planned, I need a little bit more information as to what that means. How is that information received? What's the threshold there? I think you've explained it to me offline, but how does the board actually receive this notice? Is it from code enforcement, building and safety? What is that notice? I think the more times we can clarify that would be better. And then again, I know that we don't have any actual jurisdiction over building and safety and code enforcement, but to the extent feasible, working with city agencies is not mentioned in here. And I think that we maybe should make a little bit more reference specifically on page 2 and C sub 2 or C sub 3 or C sub 4. I just feel like I need a little bit more information. And then with the mediation provision, how can we actually ensure that this is happening? Again, was code enforcement consulted, or have they agreed to this? I'm sure they have, but I'm just raising it for a flag. Is the pre-hearing mediation mandatory? I know that theoretically you have to be there in good faith. You probably can't make it mandatory, but yeah, I know.
That's right. Yeah. We offer it, we encourage it, but we don't require it before they can go forward.
Yeah, and I know. Yeah, I'm a big. I know, and mediation doesn't work if people aren't there in good faith. I definitely know that, but I'm a big proponent of mediation. I think that needs to be. Yeah, and it's less cost effective. It preserves It's more cost effective. Less costly. It preserves relationships, etc. Especially when you have an ongoing relationship with your landlord. So yeah, I mean, just for now, I didn't want to get into a line item discussion, but I think that I just need some more clarity around these points for me to feel comfortable, and I would love for in the next month the public to be engaged a little bit more here. Public, please talk to us. Staff, if there's any way to have any sort of public listening session or public comment session between now and the next, and that's what these meetings are for. So theoretically, I would love for the public to show up here, but if anyone wants to talk to us offline and give us your feedback, that would be great too.
Thank you, Commissioner Terosas, and that is a week in advance of these meetings. These agendas, these agendae are published, and we do welcome public comment during all parts of our meetings, and this was a public hearing, so we would, but in the public's defense, they did only have also 2 days to go over it. So, Commissioner Flora.
Yeah, sometimes you bring things with you that you had ideas on, and other times your colleagues talk about it, and it kind of brings it to light more for you. That's the case for me in this 24-hour period in Section B. Rereading it now and listening to my fellow commissioners, it is something that can definitely be gamed. Work can be arranged for 10 hours at a time every other Tuesday or something, so that it's not across the course of a day. I don't know how we would write it. I don't know how we would disincentivize it in the actual statute, but if language could exist that speaks to it being a little suspicious if something's seemingly 12 hours at a time 4 or 5 different times so as not to cross 24 hours. That would be wonderful if it could be created. I think a glossary of terms wouldn't be so bad either, particularly for some of us lay people that don't know a sub from a dub in some cases. And I did want to ask Commissioner Trosis, when you said the intent language was light, are you referring to Section A, the purpose of the?
I think that's a stylistic, yeah, purpose.
Okay, so that the intent language. Okay.
I feel like it could be longer, but that's stylistic.
All right. Thank you. That's it from me. I'm certainly happy to table the rest until August.
Very good. And Commissioner Phillips, I hope you feel that we did attempt to gloss over a few high-level things from a 30,000-foot perspective, not too heavy on the detail. And we do welcome everyone in the city's opportunity to take the next 30 days to look into this more carefully. We thank the staff for what must have been, a very big undertaking, and we look forward to tweaking it and fine-tuning it along with you and the public starting next month. And we do hope people will spread the word and watch the meeting, come to the meeting, write letters in advance of the meeting, whatever you feel appropriate. Moving on to the last item tonight, we have an administrative item, 12A, regarding the revised Hearing Officer 1 and Hearing Officer 2 job specifications. May we have the report, please?
Good evening, Commissioners. In 2017, in the 2017-18 annual budget, the board approved adding a new permanent hearing officer position to address a sustained increase in petition filings. When the new position is filled, the hearings department will have 3 permanent hearing officers. We plan to fill the position at the Hearing Officer 1 level. The classification specification for the Hearing Officer 1 position has not been updated for more than 20 years. Because it was necessary to revise the Hearing Officer 1 specification, the city's Human Resources staff advised us to also revise the Hearing Officer 2 specification to reflect the differences between the 2 positions. The major duties for every hearing officer are to prepare for and conduct hearings and to issue detailed written decisions on all types of petitions filed by landlords or tenants. The Hearing Officer 2 handles matters involving complicated legal issues with numerous parties or documents, such as construction decrease matters, rent increases based on a fair return analysis, and excess rent or registration matters. A Hearing Officer 1 handles more routine rent decrease matters, occupancy determinations for exemptions or rent increases for not in occupancy petitions, and less complex excess rent or registration matters. On the copies of the proposed specifications that I've given you, the Hearing Officer 2 specification has red underlining and strikeouts that show the changes that we are proposing from the version that was approved by the board in 2012. I also have clean versions of that if you'd like to look at it. The yellow highlighting on the marked up copy shows the differences between the Hearing Officer 1 specification and the Hearing Officer 2. And the Hearing Officer 1 specification that I provided you has yellow highlighting to show the differences between it and the Hearing Officer 2 specification. Human Resources staff also advised us to lower the experience requirements for the Hearing Officer 2 position and commensurately the experience requirements for the Hearing Officer 1 position in order to attract a broader range of applicants. We agree with this approach as we had a very small pool of qualified applicants the last time we hired a hearing officer, which was in December of 2012. Similarly, at the suggestion of Human Resources, we've eliminated the mediation certification requirement. We think the better approach is to hire for the hearing officer duties and train the new hearing officer in mediation after he or she has more familiarity with the rent control law. We expect this will also broaden our pool of applicants, as many applicants might not necessarily already have that certification. Upon approval of these class specifications, staff will initiate the recruitment process to fill the new position at the Hearing Officer 1 level. Staff recommends that the board approve the attached classification specifications for the Hearing Officer 1 and Hearing Officer 2 positions.
All right, we have a little bit of discussion, perhaps clarifying questions for you. First is Commissioner Flora.
Thank you. Thank you, Amy. I'm glad we're doing this. I know you need the good, solid people. Is it a bit preventative on the candidate pool side that we're requiring they be an attorney?
I think that's an absolutely necessary provision that we have, is their job is to interpret the rent control law.
Well,
And
okay.
also to understand the ability to conduct hearings, evidentiary hearings.
All right. And somebody with extensive paralegal or other types of similar experience would, I'm asking because I don't know, but I'm seeing shaking heads from.
In my experience, no, I don't
Okay.
think that would be adequate.
Okay, great. That's it.
Thank you, and I'm looking forward to hearing from our mediation expert, Commissioner Terozas.
Is it the practice of the agency to hire at a 1 and then promote to a 2, or do we ever do a 2 open competitive?
The last time we hired, we did a 2, yes.
Okay, so ostensibly you wouldn't necessarily be recruiting this person to then promote them into a 2. There could be a situation where you would take this 2 classification, minimum qualifications, and put it out into the public.
Yes, we might do that, but we also might promote from within.
Right, sure,
That's a
okay.
possibility.
Okay, well, with that being said, I think, and Anastasia previewed my comments, I think that to be a 2, you have to have some sort of mediation certificate. I think that, I disagree with that recommendation, and it's a big part of the job. And I think that a 2 level is a level that's doing more complex work. Theoretically, they've gone through all of the training. Theoretically, they're prepped to do the job of the hearing officer, and I think part of that preparation is having some sort of mediation certificate. So I'm fine with the 1 not having a mediation certificate. I think the 2 needs to have one.
I understand that. When we recruited for the hearing officer 2 last time, we did get a very limited pool of applicants, and so that was why we considered doing it this way, but I understand your concern.
I mean, I don't know, but maybe I don't know how it was promoted, but I can think of a lot of people who are very qualified and at this salary and with these classifications, with these minimum qualifications, I think that a lot of people would apply. So that's disappointing that we didn't get a lot of applicants, but I think that if you want me to help you promote, I'm happy to do so.
We would be happy to have you do that.
Thank you, Commissioner Terozas. And I'm going to let Executive Director Condon jump in here. I had the same question. A lot of the city jobs, I have local friends who've, here and there tried to apply for city jobs, and sometimes the window was open so briefly. So I just wonder, in your search, how long you're going to leave the window open?
Do you know the typical time?
Well, I think we can have some control over that. We want to advertise it widely. We want as many people to know about it as possible. So I think, if we're really eager to hire, they'll do a short window. If they're willing to let it be longer, or we can have a 2-week time period and then look at how many applications have been submitted. And if there are not sufficient number, extend the period. But with that, we'll talk about it. The other thing with the mediation training, we could make that a desirable qualification for the hearing officer level 2.
Mm-hmm.
And then when they're screening the applications, if they have enough people who have the minimum qualifications as well as the desirable, they can allow just the people that meet the desirable to also test. So that would be one way we could address the mediation requirement.
Is there banding with the?
Yes.
Yes. I almost would say both. It's a desirable qualification for both. I mean, wouldn't you?
See the harm with that?
Yeah.
I think we could
That was
certainly
actually
do that.
one of my comments. Why don't we have a desirable qualification section?
Yeah.
Maybe just like
Well, there
strongly,
is.
like mediation
in the
certificates
two.
strongly encouraged.
Well, it would
Something
be
like that.
If you look at the hearing officer 2
Sorry.
On the page 3 near the bottom, first it says what the minimum qualifications are, which are 5 years of recent paid professional legal experience, et cetera. And then below that, the desirable qualification of 3 years experience interpreting rent control or housing laws. So we can add the mediation requirement to this desirable part in both of the job specs.
Right.
So I'm next in the queue, and I will just quickly ask 2 questions. One is, the point I'd like to make is that since we do still have the ability to avail ourselves of the temporary hires, as needed hires in the interim, I would like to see, Tracy, you said if we were in a hurry, we might do a short window. If we weren't, I mean, we're in a hurry to fill the position because it's an important couple of positions, but you just said we haven't had a lot of applicants in the past. So my recommendation personally would be to have as long of a window as is appropriate and as you can. And, you know, throwing out a wider net, I think, is always better than a smaller one. And my question is, specifically, what venues, in what venues do you advertise? Do you promote? Is it only in Santa Monica? Do you throw it out on the, you know, the big ones, the Monster.coms, the Indeeds? I'm curious specifically how you market the position.
Yeah, HR does the marketing for us, but they certainly will take any suggestions.
City
that
HR
we-
or
yes,
within our own?
The city.
The city.
Right, this is a civil service position. But they will certainly take any suggestions that we have. Indeed.com, I think, is one that they use. Also, the Daily Journal will be a very good source for us, because that's the newspaper all the lawyers read. Plus, we will also put it out on the Rent Control Consortium, so they can spread the word.
And we also usually send these types of postings to Legal Aid Foundation and everything we can think of where we might find people with this type of qualification.
LinkedIn.
Very good. That answers my questions. My vote is for a longer window as opposed to shorter. Commissioner Phyllis?
I move that we adopt the administrative item with the modifications that mediation certificate is designated as a desirable for both the Category 1 and the Category 2, and with giving direction to staff that it is the preference of the board to have a fiscally responsible but longer window to encourage a broad array of applicants.
Second.
Well stated.
Very well stated.
Let's take a roll call vote.
Commissioner Flora,
Yes.
Commissioner Trosas,
Aye. Aye.
Commissioner Phillips,
Yes.
and Commissioner Foster.
Yes.
Motion carries.
And with that, I thank you all for entertaining my fumbles and bumbles along my very first ever chaired public meeting. And I declare this meeting to be adjourned.
Wait, don't we